Welcome everyone. Thanks for being here today. This is the House Committee on Judiciary and Hawaiian Affairs. It is 2 p.m. Friday, February 17th. We're here in conference room 325 in our beautiful state capitol. And we're also having this hearing via video conference. My name is David Tarnas. I am chair of the House Committee on Judiciary and Hawaiian Affairs. And to my right is Vice Chair Representative Greg Takayama and member Representative Kanani Souza. The other members will join us presently. For those who are testifying today, I would request that you keep your testimony to about 2 minutes, if you would please be so kind, and then I'll ask you to summarize. If you're testifying via Zoom, please keep your video off and keep your microphone muted while you wait to testify. When I call your name, please unmute yourself, turn your video on, provide your testimony, and then when your testimony is complete, please turn your video off and mute your microphone. If you have any technical issues while you're on Zoom, please use the chat function on Zoom to communicate with the technical staff, and they will do their best to assist you. If you're disconnected unexpectedly, just rejoin as soon as you can, and I will try to fit you in to provide testimony at that time. Please avoid, if we have to cancel the meeting, the hearing for any reason, we lose electricity or whatnot, we will reschedule the hearing and schedule a meeting for decision making, and we'll post appropriate notice. If you're on Zoom, please avoid using any trademarked or copyrighted images, and for everyone testifying, please refrain from profanity or any uncivil behavior. Please use kindness, and it's okay to disagree, but let's not be disagreeable. We're all working together here to try to do the best for this people of Hawaii. With that, let's go ahead and start our hearing. At the top of the agenda, House Bill 985, relating to government fraud, adds a new section to the HRS to establish a Class C felony offense of government fraud. First up, we have testimony in support from Judge Daniel Foley, Chair of the Commission to Improve Standards of Conduct. Then we have testimony in support from the Deputy Attorney General. Welcome. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair, Vice Chair, and members. Thank you for hearing this bill. My name is Chuk Fului. I'm a Deputy Attorney General. The department strongly supports this bill as it is a great tool to combat public corruption and fraud against the government. As indicated in my written testimony, there is currently no general fraud statute, and the current theft statutes in our statutory scheme, they don't really capture government fraud, and they don't really put government fraud in a proper perspective because it is based on money threshold. For that reason, the department asked the committee to pass this bill, and I'm here for any questions. Thank you.
Thank you very much. Next, we have testimony in support from Gary Kam, Campaign Spending Commission.
Good afternoon, Chair Tarnas, Vice Chair Takayama, and members of the committee. I submitted a short testimony in support of this bill, and I'll just stand on the testimony. Thank you.
Thank you very much. Next, we have testimony in support from the Honolulu Police.
Aloha, my name is Parker Bodie. I'm a captain with the Honolulu Police Department. The HPD supports HB 985, and we stand by our written testimony.
Thank you. Next, we have two individuals who sent in written testimony in support, Dara Carlin and Nani. Is there anyone else here wishing to testify on House Bill 985? Seeing none, members, any questions? Seeing none, we'll move on. Thank you very much. Next, we have House Bill 986, relating to official misconduct. Adds a new section to Chapter 710 HRS to establish a Class C felony offense of official misconduct. First up, we have the Attorney General.
And good afternoon again, Chair, Vice Chair, and members. My name is Chuk Fului, Deputy Attorney General. Thank you again for hearing this bill. The department strongly supports the establishment of an official misconduct. By calculation, there are approximately or more than 30 states or more than half of the states that have similar statutes. And again, this is a great tool to combat public corruption and to punish, those who commit misconduct that may not even involve economic gains. The key phrase here is the benefit other than lawful compensation, as benefit is already defined in 710-1000, that is gains or advantage to the person or even to a third party whose welfare that the person is interested in. So it covers a really broad array of misconduct for public officials. And this offense would also include the submission of fraudulent documents by a public servant in his or her official capacity. Again, the department strongly supports this bill, and I'm here for any questions. Thank you.
Thank you very much. Next, we have testimony and support from the Campaign Spending Commission.
Good afternoon again, Chair Turner, Vice Chair Takayama. I will stand our written testimony in support. Thank you.
Thank you very much. And next, testimony in writing in support from Derek Carlin. Is there anyone else here wishing to testify on House Bill 986? Yes, please. Come on up, introduce yourself.
Aloha Akayaka, Chair, Vice Chair, and the Judiciary Committee. I'm Angela Melody Young, testifying on behalf of Kapalama NSW. We're a citizens-led safety initiative we are a grassroots of HPD. So I'm going to testify just to provide comments. In our capacity, we are, volunteer safety coordinators and co-captains, and we'll step in into, things that happen in regards to public safety concerns. So law is something that we are also studying, and I hope I'm going to be quite accurate about this because AG is here. Okay, so in Hawaii, felony offenses are broken down into 3 categories defined by the state as Class A, Class B, or Class C. And every felony falls into one of these categories, Class A being the most severe felony crimes and Class C pertaining to the lesser felony crimes. Class A is usually kidnapping, arson, Class B is robbery and fraud, and Class C is usually assault crimes. If you get angry and you assault a police officer, it's a Class C felony. Within Class C is also riots. If you started a riot, it could be a Class C felony. I'd like to look at one thing in particular, harassment. I think it's petty to classify harassment as Class C felony. Because harassment is usually a petty misdemeanor. Harassment is defined as aggressive intimidation or pressure, but when it escalates, it can be classified as a Class C felony.
If you could summarize, please.
Yes, with Class C felonies, the judge hears all sides and then orders a sentence. And today, you're all the judge today. We're just providing comments about what Class C felonies are already in statute to let you choose if the measure at hand should also be considered a Class C felony. Thank you for the opportunity to testify.
Certainly. Thank you for testifying. Is there anyone else here wishing to testify on this measure? If not, questions, members? I have a couple of questions. If I could ask the Attorney General to come up, Deputy Attorney General, thank you for being here.
Mr. Chair.
And I appreciate your office putting forward this measure. I am concerned that the issue, the definition of benefit, it may have some unintended negative implications for legislators. Right now, Chapter 710 defines benefit as a gain or advantage or anything regarded by the beneficiary as gain or advantage, including benefit to any other person or entity whose welfare the beneficiary is interested. As legislators, we're supposed to be representing our constituents, so we're interested in their welfare, so we want to actually use our office to benefit our constituents. And they are, in fact, other people, right? So it seems that there could be a variety of ways in which a legislator might obtain a benefit for these other people from either doing our work or refraining from performing our official duty that are legal and proper. So I wonder whether the addition of unwarranted, the word unwarranted before the term benefit might be a way to address this. Do you feel that that might, would that be okay with you if we put the word unwarranted before the term benefit?
And thank you for the question. I appreciate the thoughtfulness of it. From the department standpoint, I think unwarranted because it still will be undefined. It actually kind of makes it more vague. But to your point, I think as to subsection A, 1A, I think that would not, your scenario would not involve in this situation because it has to be an act that constitutes an unauthorized exercise of the, person's function, right? So it already has an unauthorized exercise. I would, and I'm sorry,
About 1B?
1B, I think, from other statutes, and we were playing around with the wording too, but I believe a better way to address that would be intentionally or knowingly refrains from performing an official duty that is required by law. I think that's how a lot of other states have written like that, or have wordings like that.
So you're suggesting at the top of page 2, after the word official duty, say, as required by law?
Correct.
And in the other states that you mentioned that have similar statutes, is that how they address this issue?
Some of them, and I can look more closely.
No, that's okay. I mean, that's from your memory, that's what they use. Okay. The other question I have is, I think that there are some, I guess you might call them procedural constitutionality issues I'm concerned about, with noting that the term official capacity, that's on page 1, line 7 and 8, includes situations not covered by Article 3 and 7 of the state constitution. And I'm concerned that this basically member privilege clauses we have, for example, the privileges of members clause states that, quote, no member of the legislature shall be held to answer before any other tribunal for any statement made or action taken in the exercise of the member's legislative functions. And members of the legislature shall, in all cases except felony or breach of the peace, be privileged from arrest during their attendance. So I wonder, do other states have member privilege clauses?
I'm sure they do. I don't want to shoot from my hip, but I'm sure they do. And again, the majority of the language in this bill is I copy from other states. And to your point too, I don't think that would violate the Constitution because again, this is more the misconduct is an act that's outside your official function, even though you're acting in your official capacity.
Would you be open to an amendment to this which would be the following: notwithstanding Article 3 and 7 of the Hawaii Constitution, the term official capacity shall include situations involving actions and inactions in which legislative members are not privileged against adjudication by another tribunal, just to make it clear.
Yes, definitely. I think that would cure it.
Okay.
For sure.
Okay. Okay, I think those are my questions. Any other questions, members? If not, thank you very much.
Thank you.
All right, let's move on to the next measure. House Bill 983, relating to time limitations, defines the term, quote, public officer or employee, and defines the terms in government in section 701-108 HRS to clarify the scope and applicability of provisions relating to the time limitations to bring prosecution based on misconduct in office. First up, we have testimony and support from the Attorney General. Come on up.
Good afternoon.
Isn't it good that we've scheduled all these together?
Yes,
so that
thank you.
Yeah. Thank you. Go ahead.
Good afternoon again, Chair, Vice Chair, members of the committee. Again, my name is Chuck Fulu, Deputy Attorney General. Thank you for hearing this bill as well. This one is quite simple. 701-108 is already a very useful tool for us to combat public corruption. This statute essentially is in existence in many other states, and they're identical. However, in doing some research, we found that there are because public officer and employee is not defined, it is subject to litigation as to the scope of it and the applicability of it. So in order to avoid unnecessary litigation and to ensure the wide applicability and scope of this statute, the department, strongly supports this bill. And I'm here for any questions.
Thank you very much.
Thank you.
Next, we have testimony and support from Dara Carlin. Is there anyone else here wishing to testify on HB 983? Seeing none, questions, members? Not, I have no questions, so we will move on. Next, House Bill 880, relating to policing, requires each county police department to collect, report, and publicly publish certain data regarding police stops, arrests, uses of force, and trends. First up, we have Mr. Tommy Waters, City and County Honolulu Council Chair, in support. And we have next testimony from Honolulu Police Department, Stephen Silva, in opposition. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair, committee members. My name is Stephen Silva. I'm a major at the Honolulu Police Department, and we stand by our written testimony on this.
If I may, could I ask you to summarize your testimony for those who may not have had the chance to read it? Since it's in direct, you're opposing it and the council chair is supporting it. You're both from the city and county of Honolulu. We're
Right.
trying to understand it. So please proceed.
Okay. Basically, we currently collect and report a majority of the information that will be required by this bill. However, some of the requirements in the bill is data that we don't readily collect, such as if person's ethnicity and race on traffic citations, for example. That data is not collected. In addition to that, the data would require officers to use their perception as far as putting into the data, which would cause the data to be subjective instead of objective. So you're going to have numbers that really, what do they really mean? They're not true and factual numbers. So that is part of our concern with this bill. And yeah, that's basically it in a nutshell.
Okay. All right. Thank you very much, Major. Appreciate it. Next, we have testimony in support from Kat Brady, Community Alliance on Prisons. Please proceed, Ms. Brady.
Aloha. Thank you so much for the opportunity to testify on Zoom. We're in strong support of this measure. We believe that the data that the police department collects should represent the values of our community. So we strongly support this measure. I downloaded some information from the International Association of Chiefs of Police, and I found it really interesting because they were saying that data collection and analysis is really important to improve, how you operate. And it's interesting, I was at a meeting of Going Home Consortium on your island, Chair, and there were two policemen there who were talking about helping Going Home by collecting data for justice-involved homeless people. So after they presented, I asked, how did you do that? And they said, well, we went to the records department and we said, we need you to collect a line in the data about people who are justice involved, arrested, and when they're houseless. So it can be done. International chiefs of police support this. They believe that data and analysis is crucial to running a really good operation. So we're in big support of this, and I thank you so much for hearing it.
Thank you very much. Next, we have testimony in support from Patricia McManaman, Hawaii Friends of Civil Rights. Please proceed. Oh, not here. Next, we have testimony in support from Nikos Leverins, Hawaii Health and Harm Reduction Center. Welcome. Please proceed.
Aloha, Chair, Vice Chair, and members. Nikos Leverins of the Hawaii Health and Harm Reduction Center, and also Drug Policy Forum, testifying in strong support of this bill. As my support letter for H3RC notes, lack of relevant data impacts the ability of communities and law enforcement agencies to make informed policy and practice adjustments based on good information. Now, what I did not include in my testimony was my experience looking at very intensive data in California. I ran a request of our state's Department of Justice there, looking to reform the sentencing disparity between crack and powder cocaine in state law. And I was able to get specific demographic data from the top 10 most populous counties in California as to the race, the age, and the sex of people convicted under a single code provision. It took 8 weeks, but we got that data, and that data was used to help change the law. So this is the kind of change that we can help facilitate here with good data. So mahalo for the opportunity to testify.
Thank you very much. Next, we have testimony in support from the Civil Beat Law Center for the Public Interest, Mr. Brian Black. Next testimony in support from Ronald Fujiyoshi Ohana Ho'opakele. And testimony in support from Anthony Grise on Zoom. Nope, not today. Please refer to his testimony in our packet. Next, we have testimony in support from Emily Sarasa. Welcome, please proceed.
Aloha, Chair.
Aloha.
Vice Chair, members of this committee. I'm a 2L at the William S. Richardson School of Law. I'm here testifying today in strong support of House Bill 880. The U.S. criminal legal system is broken. Other jurisdictions have realized this and adopted measures really similar to House Bill 880 to address problems of racial bias and discrimination. Hawaii should follow this trend. This is a public health approach to public safety. We can only treat problems if we can identify them. Racial bias in policing needs to stop, and to do that we need to collect demographic data. We also should be collecting data related to mental health and houselessness issues so that we can effectively treat them. I also wanted to address the issues brought up by Major Stephen Silva. This is not a violation of the ADA or privacy rights in any way. We don't need to ask individuals to identify any disability. This is based on an officer's perception of an individual's mental health status and their English speaking proficiency. And it is subjective, but so is racial bias, and the problems that we face in the criminal legal system are those that are subjective enforcement issues. Also, it doesn't...
You can address the chair.
Sorry.
It's okay.
Habit, I think.
No, I understand. You're being polite, and I appreciate
Yeah.
that. But it's best for you to face
Okay.
up here so that the camera will be able to see you, and everyone out there will be able to see you while
Okay.
you testify. So please proceed.
Thank you. Also, the bill will not increase restraint on an individual's liberty because it won't lengthen the amount of time that an individual is stopped during investigative stops, traffic stops. This is demographic data that's basic. It would be recorded from an ID, and most of the information in traffic stops would be recorded after the stop is over. So, thank you for this opportunity to testify. I hope you all vote yes today.
Thank you very much. And I'm sure Major Silva appreciates your politeness to also look at them. So, thank you. Next, we have testimony in support from Scott Greenwood, ACLU of Hawaii. Please proceed.
Good. Aloha. Good afternoon, Chair and Vice Chair and members of the committee. My name is Scott Greenwood, and I'm Executive Director of the ACLU of Hawaii, and we strongly support House Bill 880 in its present form. As it is drafted, the bill would advance transparency and oversight and accountability for all the policing agencies in the state of Hawaii. Most of what is in the bill is simply common sense and consistent with current best practices among major police agencies. So data collection is incredibly important. As we made clear in our written testimony, it's collection of that data that leads to better analysis to identify issues within an agency and helps explain discrepancies. No less an authority than Sam Walker, the preeminent authority in police oversight and accountability, has written that attention to organization and management problems is the central thrust of the federal pattern or practice suits, the ones that result in consent decrees that have been brought against law enforcement agencies in Section 14141 cases. So it is collecting, reporting, and managing this data that helps protect law enforcement agencies and gives oversight officials a much greater sense of what is happening inside that agency. And it's because that statute calls for the development and implementation of policies for monitoring misconduct, like use of force review boards, performance monitoring information systems, and systems for oversight, supervision, discipline, and training. All of those things are possible only with this type of robust data collection and reporting. The overall strategy of any police administrator should be to develop a fact-based picture of officer activity for the purpose of identifying recurring problems that merit corrective action.
If you could summarize, please, sir.
Certainly, sir. The strategy of collecting and using that data for purposes of organizational improvement will improve the delivery of police services and transparency. So we strongly urge that the committee vote yes and pass the bill forward. Thank you.
Thank you very much, Mr. Greenwood. Next, we have testimony in writing in support from 23 individuals. And I appreciate all of them sending in that testimony. Members have their testimony in their packet. Is there anyone else here wishing to testify on House Bill 880?
Chair?
Yes. First up, Michael Goyo, please proceed.
Hi, yes. Michael Galoy Jr., Chair of the Stonewall Caucus. We apologize for our testimony being late. We stand in full support of this measure. We are kind of shocked, well, not really, that HPD is against this measure. As we've heard time and time again, when we talk about over-policing of any minority group, HPD says there is no data to that. And here they are trying to fight us from getting that data. So we hope that you will pass this bill to help, as all the other testifiers have said it more eloquently than I can. So we support this bill 100%. Mahalo.
Thank you very much. Anyone else wishing to testify? Please come on up. Introduce yourself and proceed.
Aloha Kayaka, Chair, Vice Chair, and the Judiciary Committee. Thank you for your patience. Just getting to the notes. Okay. My name is Angela Melody Young, testifying to provide comments on behalf of Kapalama NSW. And so we work closely with HPD at the front lines in our neighborhood because we respond to our neighbors' concerns about public safety. And so what we've noticed is that there is usually a gap of the policy that policymakers conceptualize and then the implementation part, right? So oftentimes policymakers think of policies that may be hard to implement, as we heard from the HPD officer here. And who's saying he may have a hard time implementing such a policy. So I like to point out anecdotal evidence, right? Anecdotal evidence is usually based on individual experience or observations as distinct from evidence that gives estimates of how likely something is to occur based on experience with large numbers of people. So anecdotal evidence is something that is subjective. And we are wondering if that's what is being asked for because if you would like objective data, you would need a professional from that professional expertise to objectively assess that demographic, whether it's medical disability or a specific culture.
Could you summarize, please?
And so, in conclusion, I think it should be considered to work directly with HPD when writing these policies. Thank you for the opportunity to testify.
Certainly. Thank you for being here today. Is there anyone else wishing to testify on this measure, House Bill 880? Seeing none, questions, members? Okay. Nope, I think we're okay. No questions. We will move on to the next measure. Thank you very much. Thank you, Major, for being here. And we'll move on to the next measures. Decision-making will be at the end of the hearing. Next, we have HB 352, relating to temporary restraining orders, allows petitioners to attend TRO, that is temporary restraining orders, hearings remotely when domestic violence or intimate partner violence is alleged or the petitioner has been diagnosed with post-traumatic stress disorder. First up, we have testimonies with comments from the judiciary. Welcome. The floor is yours. Please proceed.
Hi, thank you. Good afternoon, Chair Tarnas, Vice Chair Takayama, honorable members of the committee. I'm Andrew Park. I'm a family court judge from Kapolei, and we submitted written testimony. I just wanted to ask that this committee consider our proposed language. Note that there may be some potential unintended consequences if it were across the board shall appear remotely for all petitioners. It's possible that, for example, perpetrators of domestic violence may file a petition. They themselves would be able to appear remotely and potentially weaponize the statute. And so we think that our proposed language of may allow remote testimony and shall consider certain factors would allow us to continue to evaluate each remote testimony request based on the merits of the request and hopefully grant that to those who need it and deny that for those who aren't necessarily using it or requesting it for the right purposes. I'll stick around for any questions you may have. Thank you for the opportunity to testify.
Certainly. Thank you very much for being here, Judge. Next, we have testimony and support from Angelina Mercado, Hawaii State Coalition Against Domestic Violence. Please proceed.
Aloha. Good afternoon, Chair, Vice Chair, members of the committee. My name is Vanessa Corwin. I'm the Program Director at the Hawaii State Coalition Against Domestic Violence. I'm standing in for our Executive Director, Angelina Mercado. The coalition, on behalf of our 28 members statewide, is in strong support of this measure, as it would allow petitioners of domestic violence protective orders to testify remotely in order to show cause hearing. We know that this would result in greater safety for victims of domestic violence and address equitable access to courts by considering barriers that may be in place for survivors that prevent them from attending a hearing in person. We also respectfully suggest an amendment on page 3, lines 7 through 12. As in our written testimony, we suggest including the definition of domestic abuse in statute, as it's comprehensive and covers forms of physical abuse, dating abuse, and coercive control. That's section 586-1. We are concerned about the broad language relating to post-traumatic stress disorder, as many survivors do not have an official diagnosis of PTSD. So having to prove this in court could add additional barriers of safety for the survivor. And as domestic violence advocates, we are always prioritizing victim safety. We know that the most dangerous time for a victim is when they choose to leave an abusive relationship. So thank you very much for the opportunity to speak to our support and suggested amendments to House Bill 352.
Thank you very much. Next, we have written testimony and support from Kimmy Murphy Foster, Hawaii Women Lawyers, testimony and support from Nancy Creedman, Domestic Violence Action Center, testimony with comments from Cheryl B., and testimony and support from Dara Carlin and Dana Keave. Is there anyone else here wishing to testify on this measure? Please come on up, introduce yourself, and proceed.
Aloha, Kayaka, Chair, Vice Chair, and the Judiciary Committee. Angela Melody Young, testifying in strong support. So right now, TROs are not as constituted by statutory parameters as they should be. For example, a minor who would like to petition for a TRO can only be granted a petition if the minor petitions himself or herself, or if a state agency petitions for the minor, or if a family member petitions for the minor. In situations where a witness witnesses a minor being abused, the witness cannot petition for the minor with or without consent. And in situations when it's not a minor and it's an adult flown in from California and is a non-resident, gets abused in Hawaii by a Hawaii resident, cannot file a TRO because he or she is a California resident. So there are these loopholes in the law where petitioning for TROs can be addressed a little bit more effectively and efficiently. So thank you for the opportunity to testify.
Certainly, thank you very much. Is there anyone else here wishing to testify on this measure, House Bill 352? Seeing none, questions, members. Representative Ganadin.
To the judiciary, Mr. Fry. Hey, good afternoon.
Good afternoon.
Nice to see you.
Good to see you too, Representative
Yeah, I
Gannon.
haven't seen you here in a while. Just letting the community, I used to be a staff attorney at the Domestic Violence Action Center, and then also as a court-appointed attorney, I've represented individuals who've been respondents in these cases. Mr. Park, I'm concerned about the way the courts might view equity here for respondents. So if one party is allowed to appear via Zoom but another isn't, we might have some issues in the court taking in evidence, things like that. Would it be, if we were to move forward with this, would it be all right with the judiciary to allow respondents to appear remotely? And I think we're probably going to have to ask the same question of the coalition as well.
Well, as it stands, any party can make a request of the presiding judge to appear remotely and support that request with whatever reasons that they need. To your point, Representative Ganadin, a lot of these TRO petitions result in trials at the first hearing because it's a safety calendar, and because the petitioner is going to want to have that order converted into a long-term order for protection. There might be trial difficulties if the petitioner is appearing remotely. They might not be able to submit their evidence to the court. They might not have been able to get that marked as an exhibit. The respondent wouldn't be able to have a chance to provide whatever evidence to the petitioner. They might not be able to see it on the Zoom screen or whatever that they're using. So it could present trial difficulties, and then yeah, I mean, it's a good point, Representative Ganadin.
So I'm just trying to think out how this might happen. If a petitioner and her or his lawyer are attempting to, we pass this, they're going to appear remotely. They want to introduce evidence, but they're not, at the, like here in the First Circuit, at the Kapolei courthouse. So they can't do it in the ordinary form where they, lay a foundation, discuss the way the evidence might be presented, bring it before the court, then give a certified copy to the respondent. These are actually, rights to all parties in court systems, right? So how are we going to be able to present evidence? And this is important stuff. It might be images from injuries, blood, physical evidence. How are we going to do this if the petitioners aren't there?
They might be at a disadvantage if they're not able to enter a photograph. They may be able to publish it on their screen, I suppose, and use it as a demonstrative aid, but a demonstrative aid isn't evidence in the record. It's treated differently. So we would have to maybe have some time to rework the system if this went forward to, because as you know, Representative Ganadin, there's the Adult Client Services branch that assists the TRO petitioners in the filing, and they have already a form to allow for remote testimony that a petitioner can submit at the same time that they're submitting their petition. So there may need to be a little bit of extra instruction or extra training or extra something to help these folks know that it's going to be a different procedure if they're not going to show up in Kapolei.
I guess that leads me to the next question. Would we have to amend the rules of evidence in the family court under Chapter 586 to allow for, admitting evidence in a different way than we were trained to do as attorneys?
I don't know if the rules of evidence would or could be amended for proceedings arising under a specific chapter, but it would present issues as you say, and we'd have to work through those should this bill pass as is.
Okay, one more question, Chair.
Certainly.
Technology fails. We've, in these hearings, we have folks who are, we really want to hear from, sometimes government agencies, and, their internet drops out, something happens, and they can no longer testify. But in this case, you're trying to prove safety, and that someone needs a protective order put into place by law. What happens if and when technology fails, and on either end, like at the petitioner's end, or on the court's end, or like today it's a rainy day and the internet just drops out. What do we do then? Do we just continue the case and continue the entire trial call, or how does the court proceed?
That could be difficult if the technology fails, because proceedings under 586 have to be heard within 90 days. And if they aren't heard within a certain amount of time, then under statute, the TRO is dissolved, right? We have a certain amount of time to have the hearing, the show cause hearing, to convert the TRO into an order for protection. So in the event that there's a technological failure necessitating a continuance for the petitioner, we have to squeeze them in, right, and get them a court date. And if they're already up against the deadline because of non-service on the respondent or something like that, because they weren't available or they were evading service, that could be a problem, and the TRO might have to be dissolved under, pursuant to statute. They might have to refile it and kind of start all over again.
So quite a few things to work out if we pass this. Thank you.
Yeah. Thank you, Representative.
Yeah.
Thank you, Judge. Thank you, Representative. Any other questions, members? No, I think we're all set.
Thank you, Chair.
Yes, thank you very much. Okay, let's move on to the next measure. House Bill 573, relating to fentanyl test strips. Excludes fentanyl test strips from the definition of drug paraphernalia in the Controlled Substances Act. First up, we have testimony and support from the Hawaii State Department of Health. Nope. Next, we have testimony and support from Nikos Leverins, Hawaii Health and Harm Reduction Center. Welcome, please proceed.
Aloha, Chair, Vice Chair, members. Nikos Leverins with H3RC. We stand in strong support of this bill, and in some respects, we don't think it's really necessary, but unfortunately, it is necessary. And we hope that this bill could be expanded to reflect the more expansive provisions of SB 671, which covers all drug checking devices. Fentanyl test strips, though, are a key tool for drug users with our syringe exchange program, which has effectively reduced HIV amongst those injecting drugs for over 30 years. We've done so without incident. We're no longer distributing test strips, but there's a very real danger of fatal overdose and accidental overdose if people don't know what's in their illicit drug supply. We'd also like to underscore that due consideration be given to repealing our drug paraphernalia statute entirely as currently proposed in your HB 431, as drug paraphernalia laws do not further public health and really are not necessary for public safety either. So mahalo for this piece of legislation.
Thank you, sir. Next testimony and support from Nikos Leverins.
Stand on.
Okay, thank you. Mr. Leverins also represents the Drug Policy Forum of Hawaii. Next, we have testimony and support from Kat Brady, Community Alliance on Prisons. Ms. Brady, please proceed.
Aloha. Thank you so much for this opportunity to testify. I think I lost my video. But anyway.
We hear you.
Okay. We're in strong support of this harm reduction measure. This is really a life-saving measure. In April 2021, the CDC and SAMHSA announced federal funding could be used to purchase fentanyl test strips, and we definitely support that. I included in my testimony some of the stuff from the report that you can read, but the test strips save lives. Instead of demonizing people who use drugs, we should be looking at it as a public health problem. We must address poverty and mental health in our communities to tackle the many social issues that drive mass incarceration. With one person dying every 11 days on the Big Island from a drug overdose, often involving fentanyl, experts find it hard to believe that fentanyl test kits are not readily available at local drugstores, health clinics, or nonprofits. And we shout out to the Hawaii Health and Harm Reduction Center and Dr. Kimo Alameda from your island chair. He's really amazing. So thank you very much for this opportunity to testify in strong support.
Thank you very much for your testimony. Next, we have received written testimony and support from 9 individuals: Annika Martin, Russell Abordo, Wendy Gibson, Viviani, Thaddeus Pham, August Ahuna, Heather Lusk, Jeremy Sakamaki, Aaron Furuichi, Will Karen. Is there anyone else here wishing to testify on this measure? Come on up, please proceed.
Aloha, Kayaka, Chair, Vice Chair,
Aloha.
and the Judiciary Committee, Angela Melody Young, testifying in strong support. According to Civil Beat, under state law, fentanyl test strips are classified as drug paraphernalia. Anyone possessing a single strip could be subject to a fine of up to $500, and any adult who provides a fentanyl test strip to a minor can be charged with a Class B felony. Fentanyl test strips cost about $1 each and work similar to a COVID test. The user dissolves some of the drug they plan to take in water. After the drug is dissolved, the person dips the test strip into the solution for 15 seconds, places it on a flat surface, and waits about 2 minutes. If a single line appears, no fentanyl is detected. Double lines indicate the presence of fentanyl. The strips don't measure the amount of fentanyl, just that there is fentanyl in the drug. The purpose of this act is to amend the statutory definition of drug paraphernalia to not include fentanyl test strips because it is critically important to pass this measure because fentanyl test strips can save lives. Thank you for the opportunity to testify.
Thank you very much. Is there anyone else here wishing to testify on this measure, House Bill 573? If not, questions, members? Seeing none, we will move on. Thanks very much to the testifiers. Next, House Bill 593, relating to police reports, allows surviving immediate family members of deceased persons for whom law enforcement initiated an investigation to receive a copy of the closing report prepared by the investigating police department after a specified period of time. First up, we have testimony with comments from the Attorney General. Welcome. Come on up, introduce yourself, and please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Corey Young on behalf of the Department of the Attorney General. The bill is a really good idea in terms of getting closure for families who have had the death of loved ones investigated. Our concerns for the bill are twofold. Number one, it makes note that even in cases where criminal litigation is ongoing, it would authorize the release of these reports, and that's going to be problematic, having reports with all kinds of evidence, witness statements, confidential evidence, even photographs being released into the custody potentially of witnesses or even suspects of the ongoing litigation. Now, every trial that we have take place, the judges will institute what's called the witness exclusionary rule, basically telling the witnesses you can't talk to each other about what you testify about, telling the attorneys you can't tell the witnesses what each other are saying. Now imagine 5 years down the line, you've gone through a trial, the trial has gone up on appeal, the appeals court, the Hawaii Supreme Court has said we're remanding you for a new trial, and all of a sudden your witnesses are getting reports about what each other said in a given case, in a case where family members are involved. That would be highly problematic, and that would actually violate that witness exclusionary rule. That's one of our concerns. Our other concerns are the exceptions in 92F13. We would note some of those would be easily remedied, like the prohibition against the release of confidential personal information. The police could simply be ordered to redact that. That's not a big deal. The big deal comes in cases where ongoing investigations are not currently active, but a prosecution is still potentially going to move forward sometime in the future, even potentially against the people who might be requesting these reports. I will stand ready to answer any questions at the committee's discretion. Thank you.
Thank you very much. Next, we have testimony in support from two individuals, Dara Carlin and Monique Salgado. Is there anyone else here wishing to testify in this measure? Please, come up, introduce yourself, and proceed.
Aloha Kayaka, Angela Melody Young, testifying to provide comments. And so the purpose of this act is to provide a closing report prepared by the investigating police department after a specified period of time. So we just like to provide comments that because of the history, it seems like there was a lag, that some family members did not receive the reports. So perhaps there could be some consideration to work with the county and HPD to integrate data and maybe to upgrade the system to an APP so that the data can be automated and integrated and it can be provided in a timely, effective, and efficient manner. Thank you for the opportunity to testify.
Thank you very much. Is there anyone else here wishing to testify in this measure? 593. If not, questions, members? I have some questions for Deputy Attorney General. Please come on up. In this bill, there's a number of qualifying factors. First, surviving immediate family member of a deceased person for whom law enforcement initiated an investigation shall, upon request, be provided a copy of the closing report upon the conclusion of any criminal proceedings related to the incident, the passage of 5 years after the report has been completed, or the passage of 7 years after the underlying incident, whichever occurs first. And then it continues, provided that if the investigation has been reopened in the 6 months prior to the request, then the police department shall not be required to provide a copy of the report. Or also provided further that upon the conclusion of the reopened investigation, there shall be no further delay in providing a copy of the report. So if the investigation is ongoing, you don't have to provide the report.
That would be the hope, but it was unclear the way things were written, what reinitiated mean, because sometimes with these cold cases, what you'll see is nothing is being actively worked on. Does that mean because a closing report has been generated, would this bill consider the case then closed, and would you then need to do something in order to reinitiate it within 6 months to basically stop the turning over of the reports? Because as you noted, it's saying whichever of these events occurs first, right? So you could have a case where someone is killed, the case goes to trial, but within 5 years of that trial and the closing reports being generated, the 5 years have elapsed, so the family would again be entitled to have the reports turned over, even though criminal proceedings were actually ongoing at the time. The other problem you're gonna see is in cases like we all remember Peter Boy Kema. I mean, that was a case where immediate family members would have been entitled to get the reports on an incident that was over 7 years old, and that would have completely forestalled law enforcement's ability to obtain justice for Peter Boy in that case. You would have had parents basically able to see what all the witnesses said, what all the evidence was, what law enforcement knew and didn't know against them, and it would have been very unlikely at that point that you would have seen basically his mother and father be brought to justice after they were essentially entitled to get those reports.
In that case, in the Peter Boykema one, was the investigation still ongoing?
See, that's kind of the difficulty with the way the bill is written. I'm not sure whether they would consider, because closing reports were produced, was it closed, or whether because work is still being done, is it considered ongoing? That's sort of a soft spot in the bill where it's just unclear. Like if it's going to be any case where there's a realistic chance the prosecution still wants to push forward or maybe able to push forward with a case, then I would point you to 92F. And one of the exceptions is it frustrates a legitimate government function, and that legitimate government function is the pursuit of justice on behalf of the deceased.
Understood. Okay, could the police department simply black out information that is still under investigation, similar to when certain documents under rules of evidence are, when a portion is relevant but not the entire document?
That should certainly be done for CPI, confidential personal information. For other types of investigations, to be honest, it would depend on who's being investigated. Like if the police will know if they're being requested by, someone they believe is a suspect, and it's going to be like, what are we supposed to do? And by refusing, do we disclose to you that you're a suspect? So I'm not sure how that would work, or whether heavy redactions would be feasible. It would probably be a case-by-case basis.
Okay. All right, well, thank you. It's a very interesting bill. I think you have to keep on working on this one. Okay, thanks very much. Any other questions, members? Seeing none, let's move on to the next measure, House Bill 980, relating to forfeiture pursuant to Section 804-51, Hawaii Revised Statutes, allows notice of a bond or recognizance forfeiture to be sent to either the surety, which is the bond company, or surety insurer, that is the insurance company, by certified mail to start the 30-day forfeiture countdown for the surety or surety insurer to locate and surrender a principal, that is a criminal defendant, or file a motion or application to set aside the bond or recognizance forfeiture. This provides the state with an avenue to appeal when the court grants a motion of application to set aside a bail bond forfeiture. First up, we have testimony and support from the Attorney General. Welcome, sir. Please introduce yourself and proceed.
Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. I'm Deputy Attorney General Steve Bumanglag. The department supports this bill. Currently, bail bond companies are able to avoid the start of the search period to surrender the criminal defendant by refusing to accept the certified mail that contains the notices. And they consequently avoid payment of the forfeiture, which would be deposited into the general fund. Now, we found that insurance companies are more reliable in accepting the notices. So the bill would allow the search period to start once either the bail bond company or the insurance company receives the notice. We've also had situations where the court has set aside a bail bond forfeiture without good cause. The bill would allow the state to appeal in such situations. I'm available for any questions that we request that the bill be passed.
Thank you very much, sir.
Thank you.
Next, we have testimony and support from the judiciary, Rod Miley. Is there anyone else here wishing to testify on House Bill 980? If not, questions, members? Seeing no questions, we'll move on. Thanks very much. Next, we have House Bill 752 relating to protective orders. It allows non-residents to apply for a temporary restraining order or order for protection in cases of domestic abuse. Allows non-residents to apply for a temporary restraining order and an injunction from further harassment. On this measure, we have testimony with comments from the judiciary. Welcome back up.
Good afternoon again, Chair Tarnas, Vice Chair Takayama, honorable members of the committee. I'm Andrew Park. I'm a family court judge in Kapolei. We submit on our written testimony. I just wanted to note that the companion in the Senate to this bill, 1267, was heard this morning, and that committee adopted our proposed recommendations. And I would be remiss if I didn't note that one of our requests is that we delay the implementation a little bit because we would need to develop additional forms to allow for the petitioners who are not resident to be able to file, and then we need to make sure those forms are ADA compliant, and then run those through the electronic filing system, and then figure out a way for unrepresented parties who are not currently registered with the electronic filing system to be able to file these things if they're on the mainland or things like that. I didn't bring that up this morning. I don't want to get in trouble when I go back to the office, so I'm bringing that up now. I'll stand by for any questions that you may have.
Thank you. In your testimony, you have your suggested new language, but you also have this act shall take effect September 1st, 2023. Is that the delayed?
Yeah, that's the
date?
part. That's the part that we asked, because otherwise, I think it's as written, it shall take effect upon approval.
Upon approval. Understood. Okay.
Thank
great.
you.
Thanks for making that clear. Next, we have testimony and support from Naziha Khan, Restraining Orders Without Borders. Please proceed.
Thank you, Chair Charnas, Vice Chair Takayama, and honorable members of the House Judiciary and Hawaiian Affairs Committee. My name is Nazia Khan. I was sexually assaulted while visiting my hometown in Honolulu, Hawaii. I'm the founder of Restraining Orders Without Borders, and I'm the survivor which prompted HB 752. I always envisioned giving this testimony in person and standing at the podium across from you. But despite an effective campaign, 2 bills, this hearing, and 40,000 petition signatures, my reality remains that I'm a sexual assault survivor who is left unprotected, and being deprived of the power to testify in person is just one of many things not having a restraining order has taken from me. 13 months since my assault, I do not have a restraining order from either my resident state of California or Hawaii. California dismissed my petition because the perpetrator lives in Hawaii, while Hawaii limits its petitions to residents. This loophole is not only a gap in our statute, it's a gap in the safety and protection of one of Hawaii's most vulnerable populations. Representatives, when our laws protecting survivors are weak, our laws protecting perpetrators are inadvertently strong. Hawaii has the opportunity today to join 14 states with the most comprehensive restraining order access laws and the 25+ states which implement variations of this bill. I drafted this bill safeguarding a defendant's constitutional and due process rights because ensuring rights despite criminal history or residency status is what equality under law is. This bill ensures that equality extends beyond offenders to survivors. My sexual assault on January 4, 2022 never ended because safety never came for me. Representatives, HB 752 is the arrival of that safety for Hawaii's 300,000 survivors and 10 million annual visitors. It's time interstate violence is met with interstate protection. Thank you for the chance to testify, and I'm available for questions.
Thank you very much, Ms. Khan, and thank you very much for your advocacy for this and working with the representative who sponsored this bill and introduced it, who is here today, Representative Ichiyama. Thank you. Let's move on. We have testimony in writing in support from numerous individuals: Angelina Mercado with Hawaii State Coalition Against Domestic Violence, Derek Carlin, Carol Kwan, Dana Kiave, Sarah Pearson, Melissa Tarada, Ranuma Khan, Katie Pham, and Zoha. Is there anyone else wishing to testify in this measure? HB 752. Yes, please proceed.
Aloha Kayaka, Chair, Vice Chair, and the Judiciary Committee. Angela Melody Young testifying on behalf of CARES, putting on a different hat. We specialize in research and advocacy and education, and we strongly support this measure. And as I explained before, some of our research did say that there are not a lot of statutory parameters to help victims who need TROs. And so I think this is kind of just like a common sense thing, right? If someone witnesses abuse, they should have the right to petition on behalf of the victim, whether they are a resident or a non-resident. Anyone who witnesses abuse and has consent from the victim should be allowed to petition. Thank you for the opportunity to testify.
Thank you very much. Is there anyone else here wishing to testify on House Bill 752? If not, questions, members? Seeing none, we'll move on to the final bill on our agenda, House Bill 350, relating to child abuse reporting. Establishes that the exemption from mandatory reporting by members of the clergy does not apply when the clergy member believes that there exists a substantial risk that child abuse or neglect that is especially heinous, atrocious, or cruel, manifesting exceptional depravity, may occur in the reasonably foreseeable future. On this measure, we have testimony and support from the Department of Human Services. Next, we have testimony and support from Michael Goliach. Please proceed.
Good afternoon. Thank you for hearing this bill. Michael Galoyu Jr., Chair of the Stonewall Caucus. Yes, we believe that this bill does need to pass after we're spending way too many years talking to survivors of sexual assault as minors, that they should be able to turn to somebody to ask for help and expect to help come. And far too often, there should be no loopholes for any of these abusers out there anywhere, that they're mandatory reporting for whenever we're talking about the safety of Keiki and being sexually assaulted. So we encourage you to pass this bill. Mahalo.
Thank you very much. Next, we have testimony and support from Dana Kiave and Will Karen. Is there anyone else here wishing to testify on House Bill 350? If not, yes, please, proceed.
Aloha Kayaka, Chair, Vice Chair in the Judiciary Committee, Angela Melody Young, testifying on behalf of CARES. The purpose of this act is to require clergy members and pastoral staff to report suspected abuse. This act will require allegations of abuse spoken during a confession, which is usually confidential, to be reported. Usually, confessions within the Catholic Church is confidential. But the thing is, this measure is asking to suspend the measures, to suspend the church, the separation of the church and the state powers, so that abuse can be reported if imminent danger is present. So this measure seeks to protect children from situations of cruel abuse in which a witness has provided statements to a pastor or a clergy member, and it is imperative to address child abuse vigilantly. Although the First Amendment constitutes a separation of powers of the church and the state, and that the state must not interfere with religious practices of the church, in these situations of immediate harm, it should be considered that reporting is necessary. So there has been, according to the ACLU, in a Supreme Court decision, Carson versus McKinn, the court held for the first time that a state must fund religious activity as part of an educational aid program. And then in another decision, the court permitted prayer on a football field. So we kind of see historically, although there was a big divide between the state and the church, we are seeing a trend where the church and the state are being united, so that we can really represent what we're all about, the United States of America. Thank you for the opportunity to testify.
Thank you very much. Okay. Anyone else here wishing to testify on House Bill 350? If not, questions, members. Representative Zuno.
Thank you, Chair Tarnas. Could I get Michael from the Democratic Party on Zoom?
Yellow.
Hi, Michael. Would you have statistical data that shows children that have been abused at churches for the past 10, 15 years? And also the average, I know, my understanding is that statistical data indicates that many youth are abused, not only at church, but everywhere. But I would think that many people may share that with ministry. And if they do, I think it's the most opportune time to stop this by notifying the proper authorities and put that child in a safe space.
Unfortunately, I don't have that data on me. We are a generalist when it comes, I'm a generalist when it comes to this area. I can just relay the information that after speaking to survivors of sexual assault. I don't have that data. That would be something that RAIN could provide to you or another organization, sorry.
Okay. No, thank you, Michael. Chair, thank you very much.
Thank you very much. Any other questions, members? Seeing none, thank you very much to all the testifiers here today and those who joined us on the internet via Zoom. We're going to proceed directly into decision making. So if members would go back up to the top of the agenda and get my notes. Okay, so first up, we have House Bill 985 relating to government fraud. I'm happy with the language in this bill. I'd like to move this out as is. Questions or concerns, members? Seeing none, Vice Chair for the vote.
Voting on House Bill 985 passing as is, Chair and Vice Chair vote aye. Representative Ganadin? Aye. Representative Holt?
Aye.
Representative Hashimoto?
Aye.
Representative Ichiyama?
Aye.
Representative Iligan? Excused. Representative Kong excused. Representative Mizuno?
Aye.
Representative Souza?
Aye.
Your recommendation is adopted.
Thank you. Moving on to House Bill 986, after hearing the testimony and in conversation and dialogue with the Attorney General here, I'd like to make some amendments to the bill, so it'll be an HD1. And I would like to include language that would address the issue of procedural constitutionality. I think we can remedy that by putting in this phrase, notwithstanding Article 3 and 7 of the Hawaii Constitution, the term official capacity shall include situations involving actions and inactions in which legislative members are not privileged against adjudication by another tribunal. So that's one amendment. The second amendment would be on page 2, line 1. After the word official duty, I would put the words as required by law. So, but it would, the entire phrase would be a public servant commits the offense of official misconduct when in the person's official capacity the person commits any of the following acts, and B, subparagraph B, with intent to obtain a benefit other than the person's lawful compensation, intentionally or knowingly refrains from performing an official duty as required by law. I hope that that would address that issue. Because I'm wanting to make sure that the we have one more look at this after it goes through the Senate, I would also like to defect the effective date to 6/30/3000. So my recommendation is an HD1 with those amendments. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 986 with amendments, noting the excused absence of Representative Kong and all other members being present. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you. Next, we have House Bill 983. I'm happy with this bill. I would like to move this out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 983 passing as is, noting the excused absence of Representative Kong. Anyone wishing to vote WR or no? Chair, your recommendation is adopted.
Thank you. Next, moving on to House Bill 880. On this one, I would like to recommend amendments, so it would be an HD1. In reading the bill, there's several lists under paragraph 1, under subsection B2, and under subsection B3. I want to make them all consistent, so because I think that there's differences between the lists of required information that might be unintentional. So I want to make all of those the same and consistent throughout. I appreciate the concerns of the police, but I do think that this is doable, so I would like to move this forward with those provisions as an HD1. Members, any questions or concerns? If not, Vice Chair for the vote.
Voting on House Bill 880 with amendments, noting the excused absence of Representative Kong. Anyone wishing to vote WR or no? Your recommendation is adopted.
Thank you. Moving on to House Bill 352, relating to temporary restraining orders. I would like to amend this bill so we would have an HD1. I would like to adopt the recommendation recommended amendment from the Hawaii State Coalition Against Domestic Violence. If you see that amendment to page 3, lines 7 to 12, it would be amended to read, "The court shall allow the petitioner to attend the hearing remotely if the petitioner's allegations include at least one allegation of domestic violence as defined in section 586-1 Hawaii Revised Statutes." Then after that, I would like to have the next sentence read the language that was suggested by the judiciary. "The court shall also consider factors such as lack of transportation, childcare, and paid time off, as well as the petitioner's fear of respondent's presence." I'd like to move it out with those two amendments because this already is specifically for the petitioner to request it rather than the respondent to request a TRO. I'd like, just to make sure we have another look at this as it moves through, I would like to defect the effective date so that it can come back. I appreciate Representative Ganadin's numerous questions about the practicality of this and the other concerns, so I want to have another look at it. So I'd like to defect the effective date so we can make sure we have a look at that. With that, that's my recommendation to move out on HD1. Questions or concerns, members? Representative Ganadin.
Thank you, Chair. In full support, I think that if we're going to proceed with this, we just need to have a note to try and determine how evidence is going to be presented by the petitioners pursuant to law, basically. And, you know, different courthouses do this in different ways. Over the years, I've done Chapter 586 hearings in Hilo, Wailuku, and Kapolei, and it kind of matters what judge you're in front of. So I think we're going to have to clarify how this is going to get rolled out.
Thank you. I'd like to include that in the standing committee report so that that's very clear as something that needs to be done. So let's do that. Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 352 with amendments, noting the excused absence of Representative Kong. Anyone wishing to vote WR or no? Your recommendation is adopted.
Thank you very much. Next, let's move on to House Bill 573 relating to fentanyl test strips. While I appreciate the recommendation from Mr. Leverins to broaden this to include other drug paraphernalia, the titles is specific to fentanyl test strips. We're going to stick with that. And so I'd like to move this out as is. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 573 passing as is, noting the excused absence of Representative Kong. Anyone wishing to vote WR or no? Chair, your recommendation is adopted.
Thank you very much. Let's move on to House Bill. Let's see, that was 573. Okay, we're moving on to House Bill 593 relating to police reports. I would like to move this out with an HD1 just to make sure. I mean, I think that this can work as it is written, but I want to sunset it in 2 years so that we can make sure that if there's problems that this is just going to go on. So I would just like to keep the effective date as it is, but sunset it in 2 years. That's my recommendation. Questions or concerns, members? Not, Vice Chair for the vote.
Voting on House Bill 593 passing with amendments, noting the excused absence of Representative Kong. Anyone wishing to vote WR or no? Your recommendation is adopted.
Thank you. Now moving on to House Bill 980. My recommendation is to pass it out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 980 passing as is, noting the excused absence of Representative Kong. Anyone wishing to vote WR or no? Seeing none, your recommendation is adopted.
Thank you. Next, moving on to House Bill 752, I would like to adopt the recommended language in the amendment from the judiciary. I'd like to adopt it in its entirety. So it's on page 2 and 3 of their testimony where they have made their recommendation, going all the way on page 3 to section 4 where it says this act shall take effect September 1st, 2023. So it'll have that as a clean date, language that I think we can all live with. So with that, I'd like to move out HD1. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 752, passing with amendments, noting the excused absence of Representative Kong. Anyone wishing to vote WR or no? Seeing none, your recommendation is adopted.
Thank you. Finally, I would like, let's move on to House Bill 350. I'd like to make some additional amendments so we would have an HD2. We need to make some technical amendments, but I would also like to adopt the recommended amendment from the Department of Human Services, page 4, lines 7 and 8. They recommend a clarifying amendment to delete the term other than a penitential communication. They rightly describe this as being confusing to the reader as it comes after the newly added reportable information, and I don't think it's necessary. So with that change, I'd like to also make it effective upon approval. So it's a clean date, we can move it out. With that, any questions or concerns, members?
Concerns.
Yes, please, Representative Souza.
Thank you, Chair Tarnas. I do have concerns. I'm in strong support of this bill, and thank you to the introducer who sits on our committee for introducing this very important bill. I do feel, however, that we should go one step further, whether it's now or in the future. And subsection 350, 1-1, I believe, section 10, I believe all the language pertaining to the exceptions should be stricken. I don't think there should be any exceptions when it comes to the penitential communications. I think that this bill does a very good job of trying to strike a balance between the sanctity of penitential communications and disclosure. However, I think the ultimate implementation, if this becomes law, will miss the mark as far as protecting our keiki. I think that we need to provide no exceptions for the clergy, and it should just be strictly mandatory reporting. Also, just a note that the Seattle Times editorial board is also grappling with the same situation in Washington State, and they put out an editorial yesterday that the title is Mandate That Washington Clergy Report Child Abuse Without Exceptions. So thank you so much.
Thank you very much. I appreciate that suggestion. I think I'd like to move this out with the recommendations that I've made, but should you like to propose such a future bill, I would certainly be interested in hearing it.
Thank you.
Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on House Bill 350 HD1 with further amendments, noting the excused absence of Representative Kong. Anyone wishing to vote WR or no? Seeing none, Chair, your recommendation is adopted.
Thank you very much to all the testifiers, to all the members. We'll be reconvening for our next hearing on Wednesday next week, so look forward to seeing everybody then. Have a wonderful weekend. There's no further business before our committee today. This hearing is adjourned.